Imagine exposing a corporation online. A video, a report, a post, maybe even a comment. Everything you said might be true. But then a lawsuit arrives, not because they expect to win, because they know the legal process alone can drain your savings, destroy your focus, and scare everyone else into silence. There is a playbook. It doesn't get published and it doesn't show up in press releases. But it exists, and corporations have been running it for decades. The goal isn't to win in court. The goal is to make sure you never get there. It's called a SLAPP, a strategic lawsuit against public participation. And in 2025 and 2026, we're watching it deployed at a scale that's difficult to comprehend. A pipeline company, an environmental organization, $345 million, and a legal strategy designed not just to punish one group, but to send a message to every activist, every journalist, and every creator who might think twice about speaking up next time. This is the complete strategy decoded. Step 1 is always the same. Find the speech. A SLAPP doesn't begin in a courtroom. It begins in a monitoring operation. Large corporations, particularly in the fossil fuel, real estate, and pharmaceutical sectors, maintain legal and PR teams whose entire job is to track criticism. They watch social media. They read investigative reports. They flag online creators, nonprofit campaigns, and community organizers who are gaining traction on narratives the company doesn't want amplified. A SLAPP can be triggered by something as small as a blog post, a comment on someone else's article, a letter to a newspaper editor, testimony before a legislature, or circulating a petition. The target doesn't need to be a major media organization. In fact, the point is often specifically to go after someone small enough that the legal costs alone will be catastrophic. One of the clearest signs that a lawsuit is a SLAPP is that it targets outspoken individuals rather than the organizations they represent, isolating the person most responsible for the speech, cutting them off from institutional support, and maximizing the personal financial pressure. Step 2 is choosing the weapon. The most common vehicle is defamation. A corporation alleges that a critic published false statements that damaged its reputation or business. But the filing doesn't have to be defamation. It can be tortious interference, claiming the speech disrupted business relationships. It can be trespass, conspiracy, or civil RICO, which allows plaintiffs to demand triple damages and attorney's fees. In some cases, large numbers of aggressive pre-action letters arrive before any formal lawsuit is ever filed, and those letters alone are enough to silence targets before a single courtroom door opens. The claim doesn't need to be strong, it needs to be expensive to fight. A lawsuit that costs $200,000 to defend against and ultimately fails has still done its job if the defendant spent 2 years and their entire savings proving it had no merit. Step 3 is choosing the battlefield. Forum selection is one of the most important and least discussed parts of the corporate SLAPP strategy. Selecting a forum that's onerous for the defendant is a recognized marker of abusive litigation. That means filing in a state with weak or no anti-SLAPP protections. It means filing in federal court when the defendant is more exposed there. It means choosing a jurisdiction geographically distant from the target, forcing them to hire local counsel, travel for depositions, and absorb costs that compound at every step. For activists and environmental organizations, this has meant watching corporations file in North Dakota rather than California, in Virginia rather than Oregon. The choice of jurisdiction isn't administrative. It's a weapon. A defendant who would be protected by California's anti-SLAPP statute, who could get the case dismissed in 60 days and walk away with their legal fees covered, has no equivalent protection if the case lands in a state with no such law. Step 4 is the discovery machine. Once the lawsuit is filed and the forum is locked, discovery begins, and this is where the real cost accumulates. Discovery in civil litigation means producing documents, sitting for depositions, responding to interrogatories, and each of those has a price. Corporations with dedicated legal teams can weaponize the process by making discovery requests as broad and burdensome as the rules allow. Prolonging proceedings through delays, excessive discovery requests, and amended pleadings is a documented SLAPP tactic. The goal is to keep the meter running. Every month the case continues is another month the defendant is paying legal fees, living under the stress of litigation, and being pulled away from the work or the speech that triggered the lawsuit in the first place. Standing Rock organizer Crystal Two Bulls, sued in connection with Dakota Access pipeline protests, said that being sued tangled her up practically and emotionally in a legal battle that diverted her attention from her work on climate and indigenous land rights. She began to censor herself. She withdrew from her community and the movement. That withdrawal is the victory condition. The lawsuit doesn't need to succeed. It already succeeded. Step 5 is the verdict that isn't really the point, and the appeals that keep going anyway. SLAPPs don't usually win in court, but that's not what they're designed to do. They're built to drain the financial resources of critics, unfolding as years-long wars of attrition where corporations grind down the financial, emotional, and legal capacity of their targets. But sometimes they do win, and when they win in a jurisdiction with no meaningful anti-SLAPP protections, the results can be existential. In March 2025, a North Dakota jury found Greenpeace entities liable for their role in supporting protests against the Dakota Access Pipeline, delivering a verdict of more than $660 million. A judge later reduced that figure. The final judgment ordered Greenpeace to pay $345 million to Energy Transfer, plus 11% interest from the date of the jury verdict. The Greenpeace International Executive Director called it the biggest damage award ever imposed on Greenpeace organizations and said plainly, it's meant to shut the movement up. Pursuing appeals with little or no prospect of success is another recognized SLAPP marker. Keeping the defendant in the system, keeping the financial pressure on, and keeping the story alive as a warning to everyone watching. Energy Transfer's lawsuits are part of a documented wave of abusive litigation filed by big oil companies including Shell, Total, and Eni against Greenpeace entities in recent years. This isn't a one-off. It's a coordinated industry response to environmental advocacy. Step 6 is the chilling effect, and this is the one that rarely gets discussed. Heavy-handed threatening letters can be enough to silence critics even without a formal lawsuit ever being filed. When a $345 million judgment against an environmental nonprofit makes international news, the calculation for every smaller organization, every independent journalist, and every creator covering corporate misconduct shifts. The message doesn't need to be spoken aloud. It's already been delivered. A report from Earthrights International found the fossil fuel industry alone used SLAPP tactics to target more than 150 people and organizations over a single 10-year period, and that's just the documented cases. The threatening letters that never became lawsuits, the creators who quietly deleted their videos, the journalists who killed stories before they were published. None of that appears in any database. Filed cases are only part of the problem. So what does the defense look like? Anti-SLAPP statutes remain the most powerful tool available. California's law, which freezes discovery, shifts the burden back to the plaintiff, and mandates fee shifting, is the model. The European Union's anti-SLAPP directive came into force in April 2024, and Greenpeace International has already invoked it, filing suit against Energy Transfer in the Netherlands. That case was registered in the Amsterdam court docket in July 2025. The first major test of the EU directive in a live transnational SLAPP dispute. But in the United States, there is still no federal anti-SLAPP law. The patchwork of state laws means the protection you have depends entirely on where the lawsuit is filed, and corporations know exactly how to choose. The complete strategy decoded: monitor the speech, choose the weapon, pick the weakest battlefield, weaponize discovery, run the clock, collect the judgment or just the fear, and watch everyone else fall silent. It works because the legal system was not designed with this use in mind. It was designed to resolve genuine disputes. When you run genuine dispute machinery on a bad faith objective, the machinery doesn't know the difference. It just runs. The only way to stop it is to build systems that recognize the pattern. Anti-SLAPP laws that work at the federal level, fee shifting that punishes abusive filers, courts with the power to identify and dismiss meritless claims before the discovery machine turns on. Until then, the playbook stays open, and the next target is already being identified.